Hello, everyone. Welcome to Court Chatter Live. I am Cathys Question from CourtChatter.com, and on Twitter you can find me at Court Chatter. We are going to talk again about the Justin Ross Harris hot car death trial. We had a great show, fantastic show last week. If you didn't catch it, you can go back and catch it in our archives with legal analyst Phil Holloway, and where we talked about the case and took a lot of questions. And today we're going to concentrate on the defense case because now the state has rested. I have to mute sorry about that. The state has rested and the defense has started their case. So I think it's a good time to maybe talk about the defense in this case. And we'll also take your questions. So you can, right now, if you're watching this live, you can post your questions in the chat box to the right of the screen. And my moderators will make sure I get those. You have questions for Phil. And afterwards, if you're watching this not live, you can make comments below the video, and I will go in and check those during the week and try and answer your questions then. So without further ado, I'm going to bring up Phil Holloway. Hi, Phil.
Hey.
Okay, I'm just going to remind everyone that you have been a police officer, you have been in the Navy, you have been a prosecutor, and you are now a defense attorney. So there's nothing you don't know about all this legal stuff, which is why you are
a judge.
You what?
Occasionally I've been a judge, as I said.
Occasionally you've been a judge. Okay, so I also want to say that this is the first time we are streaming from Phil's office, and I don't think the Wi-Fi is great. So I hope it turns out okay. Actually, I'm looking at it. It seems a little better, but I hope the sound isn't too bad. And you guys let us know in the chat room how that's going. Okay, we're going to dive in. The state rested on Friday, I think it was. And then Monday morning they called, and of course it was Halloween. And of course it was, here, let me put me back up for a minute. Of course it was Halloween. And we're all busy trying to do kid stuff. And especially my kids were out of school, which our county has done that for years now, where they make that like a teacher prep day. So anyway, that's the day Leanna came to the stand. So Leanna Harris, no longer Harris, now Taylor, because she has divorced him. Cooper's mother was on the stand Monday and Tuesday. And I think we're going to concentrate mostly on that. And maybe if I can just start out, Phil, and just kind of give me just a brief overview of your take on that testimony in general. What did you get out of that?
Well, Leanna was a necessary witness. The defense really didn't have much choice but to call her because she is the person who knew Ross Harris. If there was one person in the world that you could point to that knows him better than anybody else, it had to be her because she spent more time with him. Now, we obviously know that he spent time elsewhere as well, but if you want to bring somebody in who's got a really solid opinion about who your husband is and what his relationship was like with the child, Leanna's the person. So she can hate him. She can be disgusted by him. She can really hope she never sees him again in this life. But if you want to bring somebody who knows the most about the relationship between Cooper and his father, she's the one. So the defense had to bring her to give that opinion. It's called a lay opinion as opposed to an expert opinion. But in Georgia, lay opinions are allowed if the person has a substantial basis for being able to explain why they have that opinion. So it's true that she thinks it's an accident. She's very clear about that. She says there's no way he would have hurt his child. At the end of the day, she wasn't there with him. She can't get inside his head, and she can't, if anything, he was thinking or not thinking when he left the Chick-fil-A.
Right. Okay, so my non-legal take as a juror member is, hey, when you have Cooper's mother on the stand who believes this was an accident, you always have people on the victim's side, right? They're on the prosecution side of the courtroom. They're there to represent the victim. They want to see justice. We don't have that here because nobody on either side of the family believes this was an intentional act. So even Cooper's mother isn't there to see justice done. So that I think should play well for the defense. I think there were pros and cons about her testimony, and we'll get into more detail about that. But I would say overall, in general, that's a great defense witness because that's the victim's mother. However, she's got cons as well. Okay, this is what I think I'll do. I'm going to start with a question from, let me see. I'm going to start with this question from Kathleen. She wants us to go over the charges again. Now, if for those that are watching this, go back to our archive from last week's show, and it starts at about the 24-minute mark. Phil does a great explanation of these charges that seem to be confusing a lot of people, so please go back and watch that. Kathleen says, it seems that most of this hangs on convincing the jury of the malice. Absent that, it seems like it's not likely to hold him accountable for his death. At least that is what she's seen. Are these charges complicated for just me, or could the jury have trouble with them? And are they going to get cleared up better for them with jury instruction? Could there be a better charge for the state to use that more clearly defines negligence, or is this the best they could do? The malice seems pretty tough. So that's from Kathleen. If you just want to, briefly go over that.
All right, so all the sexting charges, well, let's just go ahead and state it. I mean, it's obvious that they've conceded those. I mean, I don't think that anybody really disputes that the young ladies that came in and testified as the victims of the sexting charges are not telling the truth. So I don't think that there's really going to be any question that he's going to be convicted on that. The other charges, the cruelty to children, there's two types. There's cruelty in the first degree, and there's cruelty in the second degree. Cruelty in the first degree is predicated on malice, just like malice murder is. Cruelty in the second degree is predicated on criminal negligence, which is more than mere negligence, like in a car crash, but it's criminal negligence. There are two murder charges that are felony murder based on those two cruelty felonies. Okay, so counts 2 and 3 are felony murder, one of which is based on the cruelty in the first, and one is based on cruelty in the second. Count 1 is malice murder. That would be your garden variety murder, as if someone premeditated, deliberated, with malice of forethought, went in and killed somebody. Okay, that's sort of garden variety murder. The felony murders, you've got to have this underlying felony. So if you don't have malice, you don't have cruelty in the first degree, therefore you don't have felony murder based on cruelty in the first degree, and you don't have malice murder. If you have criminal negligence, you can have a conviction.
Hang on, let me stop you. Sorry, let me stop you. So why have the first felony murder charge that has to do with cruelty to children involving malice, if really it's kind of the same as the count 1, or am I making that too simple?
It's going to be a question that I want to sit down with folks, hopefully if they'll answer this question after this trial's over. I'd like to know why it was charged that way, because count 3 and count 1 are sort of inconsistent with one another in that are you negligent or was it intentional?
Right.
Okay, so
well, it's almost like a lesser, right? A lesser included right up front for the jury.
Well, it's not really a lesser included, because the conviction for felony murder on count 3, if he's convicted, he can get life without parole, just like he can get life without parole for malice murder. So on count 3, it's essentially charged as an unintentional death. Count 1, it's charged as intentional or malicious. So I think that the thing might have been, and I'm speculating, I don't speak for the DA, I don't know, but the thinking might have been, look, if get its head wrapped around malice, and that's where a lot of people are right now, they might be able to get their head wrapped around criminal negligence, because if you're on a whisper app talking about extramarital activities as you're driving to work when you're supposed to be taking your child to daycare, and then you forget your child because you're too distracted with your phone, then there's a stronger argument to be made for criminal negligence. So some people seem to think that that's where the case is right now, and that it relies on criminal negligence. But I can tell you, the argument is not dead yet. We will see more of it. We're going to hear about it in closing argument. And the prosecutor is not giving up on that, because there are some things that you can make a case for malice. There really are.
Oh, so that's interesting, because I'm totally not there. I'm
not saying I'm there either. I'm saying there's an argument to be made for it.
Yeah, I'm not there on count 1 or 2. I find, I don't know if I want to say the majority of watchers feel that way too, but probably over 50% feel that he's not there, that the state has not proven counts 1 and 2, but feel like there's a very good, strong case with count 3. And I think that too. I could argue both ways if I was sitting in the jury room. So that'll be interesting to see how the 12 people go on the criminal negligence. You know, maybe they're going to find malice murder. Maybe they're just going to say, look, this cute little boy that we saw in those videos baked in a car in a horrible, awful death, and his dad is a creep and a pervert and a lousy guy, and maybe those 12 jurors are just going to go, jury nullification, right?
Well, that's true. I mean, or it could be a hung jury and a mistrial on some of that.
Well, I actually think that's what's going to happen on the malice counts.
But to play devil's advocate, and again, I'm neutral. I don't have a dog in this fight. I don't know what happened. I don't know all the evidence yet. But I do know a few things. And if I were to be a prosecutor in this case, I think the argument that I might make in closing arguments based on what I've seen would go something like this. You know, he was seen in the police video before the questioning began when he was by himself. The first words were, "What was I thinking?"
Which
what
could be
was I thinking? Away. Okay. So if you combine that with the idea that it is possible to have genuine regret that you've done something really, really bad, and you can even have genuine grief because you realize you've just killed someone you love. How many murder cases have we seen where people kill somebody that they really love? Okay, so it's not uncommon that people kill somebody that they love. So we can have genuine grief, we can have genuine remorse, we can have genuine regret even, okay? And you can have all those things, but what you might not be able to have is a drive from his workplace, the treehouse location, 6 or 8 minutes in length to the location where they finally stopped, with an admission that a mere glance to the right and you can see the baby's head. You can't have a drive of that long without glancing to the right only one time. Okay, I did that. I've actually done that drive, and I can tell you that.
Oh, I want to talk about that.
You glance. You know, there's lots of turns. There's a right turn leaving the treehouse. You go through a couple of lights where you've got to look both sides, looking for traffic. If you're driving. Hang on
just a minute. So let me just tell everyone. Today, Phil did that drive. He did the exact drive. He took all the routes and he videoed it, and we are going to have that uploaded somewhere later, and I will let you let me know.
By no means scientific, and it's not a perfect recreation,
of course.
But it just happens to be in the general area where I was running errands, so it wasn't like I went out of my way to do it because I'm over in this area all the time, and I'm very familiar with it. But you know, I can tell you that you glance to your right a lot, at least I did, okay, making that drive. So the argument is going to be made to the jury that it's just common sense that if he's lying about that he had to have looked to his right before that final spot where they came to rest. It had to have happened. And if you don't believe his story about I didn't see him until then Ross Harris's entire version of events goes out the window, and they're suddenly at malice. So there's a way to get to malice. Whether or not the jury is going to be able to find their way there is the big question. But the prosecutor does have an argument.
I think that is always a big problem in a lot of trials are the jury instructions and how confusing things are for these just normal, average citizens that don't really care about all this legal mumbo jumbo, and they get lost in the weeds in that. And I have interviewed people that have sat on the jury of some of these cases, and they have a hard time, and that's why we see questions come back out for the judge during deliberations. They really need to make those better.
Well, I wish there was a way to make them better. And quite frankly, unless I'm the lawyer in the case and I'm stuck there, when I'm actually watching a trial in Georgia, they lock the courtroom doors during that charging of the jury. So I get up and leave before that starts because I can't stand it. And I've seen juries come back with an acquittal because they just can't get an answer to the question. They can't get the judge to give them a straight answer. They don't understand the question. So yeah, it can happen.
Okay, let's go. I want to talk about Leanna's testimony, and then I'm just going to start running through all the questions. We have a whole bunch of questions coming in. I'm not going to group them into different categories. We'll just start going through the Q&A, but I do want to talk about Leanna's testimony. These are some of the comments that were going on during her testimony. That she's showing no emotion, that she was, when we thought she was emotional, she was fake crying, that this is not a mother of a 2-year-old that baked to death in a car. This is not how that she should act. Why is she still defending him after everything she knows now? Why is she still defending him with all the sexting and physical affairs that he had, and a prostitute a few times? Those are all the comments that are coming out the entire time Leanna is testifying. And if those comments are coming from trial watchers, then they're in the heads of jurors. That's how I always judge these things. Now, our trial watchers are a little more astute than the jurors because this is what they do for a hobby and they like it. So they do know more things. However, I kind of judge the chatters in our chat room up against a jury. And a lot of times the verdicts, even when they're a hung jury, come out like the chatters are. So I do believe that that's going through the heads of those jury members about her whole demeanor. What do you say about that as an attorney?
I saw some actual wetness underneath her eyes, so I know she was really crying. And I think that it was made perfectly clear by not only the defense but the prosecutor as well that at first they were at least suspicious about the way she was acting, but over time they came to see that she really wasn't involved in this. And I mean, if she were going to be accused of this, they would have gone after her a lot more aggressively than they did on cross-examination. So I think it's perfectly obvious at this point that nobody, not even the cops, think that Leanna Harris had anything to do with it. So the biggest benefit to Leanna was the fact that she got to get out there and publicly tell her story, and I think dispel any reasonable doubts about whether or not she was involved in it. I think a lot of people might still believe that she was. I'm not one of them. I think it's obvious that if this was intentional, it was only intentional by Ross Harris. There was no conspiracy between the two of them. What's in it for her? I mean, nothing at all is in it for her to have her son killed that way. So I think she came across as truthful. I think she came across as credible. But what she cannot do for the defense, and there's just no way around this, I don't care how good of a defense lawyer you are, she can't tell the jury what was in Ross Harris's mind when he pulled out of that Chick-fil-A.
Well, and that's the biggest thing, right? That's the biggest point that you even tweeted about. All these witnesses that are coming up for the defense don't know everything about Ross Harris, even though they've known him since high school, known him since whenever, because none of them knew about this double life. Some of them that have testified knew that he had an addiction to pornography, and actually Leanna knew that because he sought counseling for that. So they knew little pieces, but nobody knew this whole other side of Ross Harris. And that was kind of your point, your takeaway from all these defense witnesses so far that are coming up talking about what a great guy is, how much he loved Cooper. He was so excited to be a dad. Everything they saw about him was that he loved Cooper. And then ADA Boring will just get up there every time and say, did you know he was sexting with this minor? Did you know he went and was with a prostitute? And they didn't know. And so,
the idea is if you don't know, if you feel like you know somebody really well, but then there's something that's so far beyond what you think you might have ever expected, then the idea is that if you don't know that, isn't it possible that this person could be plotting to kill their son and you wouldn't know it? And I got to tell you, speaking of Boring, I like him. He's a friend of mine, but I tell you, he showed great restraint with some of these witnesses. He could not have gotten away with this with Leanna or probably the grandmother, but with some of these other witnesses, like her best friend, who was, said she didn't trust the prosecutors and things like that, I might have gotten more aggressive and gotten in her face and actually showed her one of those pictures. And you say, is this the kind of soul that you're here to tell the jury about? This is the person who sent this picture right here?
Have that moment.
The text messages. Hey, you want to come over and do this, that, and the other with me today? Is this the Ross Harris that's such a great guy? I might have been a little bit more aggressive in that regard.
Okay. I'm going to get in trouble from my chatters in my chat room because we try not to speak of the Jodi Arias trial, and now that I've said that name, I have to pay the swear jar for it. But Juan Martinez did that in the Jodi Arias trial, and he pulled out pictures that nobody wants to see and just flashed them up on the big screen in the courtroom. Travis's slit neck from side to side. Did you know that Jodi was capable of doing this? That kind of stuff, and sexual pictures. And he did that. He pulled that out with these character witnesses that came up for her, and that's exactly what he did. They call him a bulldog, and he went right at him. And so you're right, Boring showed great restraint, and he didn't go that way. There's different rules of thought on that, on what's the best way to be, and I'll get massacred for this, but I didn't always agree with Juan Martinez's ways. But anyway, I do think he's a fantastic prosecutor. Okay, I'm going to jump into some questions here. So I'm going to pull you up on the screen. Okay. Val wants to know, why didn't the prosecution go into depth of Harris's sexual addiction? Why didn't they go into the particular websites and or porn sites he visited?
If I had to guess, it's because they don't want to. They know their case is going to take long enough, and they know that this jury's only got so much of an attention span. The parade of young girls and women that were just back to back to back to back to back, comes in, and at some point it's overkill. It's beating the proverbial dead horse. It's over trying the case. Unless he went to a website that literally advocated killing your children, okay, then if he goes to any given pornography site, what really does that add to the case? We know that he's got a problem with sexting. We know that it's apparent that there's looks like an addiction to this. We know that he has erectile dysfunction at home but nowhere else. So I think at some point it's overkill. These are jurors that are perhaps religious people. They are people that might have delicate sensibilities, and so you don't want to just start flashing that stuff up on the big screen for them. They get it, they know it, but they don't necessarily have to see it.
I agree with that, because I think they've got plenty on the sexting charges for him already, and I don't know how much pornography he watched over and over really has to do with wanting to kill his son. So, okay, Maria has not been impressed with the defense at all so far, and she doesn't think their questioning has done anything to humanize Ross. So she says, Phil, if you were to be hired by the defense team as an advisor, what would you have done differently? Do you think the defense is working under the premise that the state has not proven malice, and therefore their strategy is to just show Ross's bad side, like he just had a double life? He was a creeper on one side. I'm now putting my own words in, and that has nothing to do with him being a good father. All right, so that was a lot for you.
All right, so if I were, first off, I think the defense is doing a good job with what they've got. You got to play the hand you've been dealt, and they have a client that is absolutely despicable. So they're not even going to try to make the jury like him. They don't need to humanize him. What they need to do is to plant seeds of doubt that even though he may be a terrible person, that he's not quite that terrible. He's terrible in other ways, but he's not a murderer. And who are in our prisons and our jails who do really, really bad things, but they got to draw the line somewhere. So they want to point this person out as a flawed, deeply flawed person, but one who, would never quite go that far. So they're doing the best they can with what they've got, but it's very difficult to prove a negative. You can't prove that it wasn't intentional unless there's some alibi or something like that, which in this case, it's just not that type of a trial. It's really almost impossible to prove that something did not happen or that you lacked a certain intent. And for the same reasons it's hard to disprove it, that's the reason the prosecutor is going to have the challenge proving it, because, again, you've got to get inside his head, and the only one who knows for sure what his intent was is Justin Ross Harris.
That's right. Okay. What we've seen so far on the defense, by the way, we're still in the defense case. They're not done. Experts are going to start testifying tomorrow, and we can talk a little bit about that. But what we've seen so far are kind of character witnesses, right? So we've had Leanna on. We've had best friends since high school. We've had church Bible group members. We've had lots of Home Depot co-workers. That's what we have. So to go with that, Flower's question is, do you think the family and friends have helped the defense or the state more?
I think to the extent that they have perhaps planted the seeds of doubt on the issue of malice, they've helped the defense. They have not really helped the defense get around criminal negligence, except, let me put an asterisk by that answer. One of the last witnesses we saw was somebody who was his, for lack of a better, he would be like the person's sponsor if you were in a 12-step program. Okay, so his testimony was that when Ross would feel like he's relapsing, I'd help him get him back centered. So they're starting to get into this issue of pornography addiction and sex addiction, and if you're going to make the argument that it was ordinary negligence and not criminal negligence, if you can point to specific examples where Ross was trying to deal with his addiction, he was trying to get treatment, if you will, then it's easier to argue that it was a simple act of negligence as opposed to criminal negligence. It may be a long shot. I'm not saying it's going to be a winner, but look, you play the hand you've been dealt, and if pornography addiction defense is what you got, then you have to go with that.
Okay, let's briefly talk about the search warrants. There was there's pretrial hearing where the defense wanted a bunch of the search warrants thrown out, and then the fruits of the poisonous tree and all that. But here, and the judge denied that. Here in trial, since the defense case started, they called Detective Murphy up to the stand, who was the one who was largely in charge of getting the search warrants, and he swore affidavits out to get these search warrants. But he used information that he got from Detective Stoddard to get those search warrants. So Baltimore Joe asked, given that a lot of the search warrants were based on stretches of the truth or maybe outright lies or misinformation, how likely is it that a higher court might now throw the fruits of the poisonous tree out? So, you know what he means by that. Is that appealable?
Well, we're commingling legal issues here. The fruit of the poisonous tree has to do with whether or not the judge pre-trial should have suppressed evidence seized on the basis of those warrants. And police officers are allowed to collaborate. They're allowed to talk to one another and rely on what each other has said when they go get warrants. So Detective Murphy was not there when Harris was interviewed. He did not examine the computers. He did not know what Harris may or may not have searched for. He got some information, presumably from Stoddard, maybe from Stoddard and others, because there was more than obviously one person working on this case. So he got some information. He went and presented it to a magistrate judge. And he wrote it up. He's the typist, if you will, that wrote it up, submitted it to the magistrate judge, and turns out some of it wasn't accurate. And the question is, was Murphy lying to the magistrate judge? I don't think anybody suggested that. By all appearances, Murphy honestly believed that what he was writing in the affidavit was true. And it's possible that the police even collectively thought all this was true because it was in the very early stages of the investigation and it was evolving. So I'm not prepared to call Stoddard or anybody a liar, but it is obvious that they were incorrect, that they were barking up a tree that didn't exist. And the defense wanted to point that out. And see, it all goes back to the idea that a good investigator is going to be objective and they're going to follow the evidence to the truth wherever it may lead. And they want to point out that the Cobb County Police jumped to a conclusion and that they built their case around a faulty assumption to start with. And so you heard the phrase garbage in, garbage out. If you start with a faulty presumption of what happened, your investigation is going to be going off course from the very beginning. And that's at the heart of the defense's case. And that's what they were desperately trying to get at through not only Stoddard, but through Murphy. And if they had asked Stoddard directly about the warrants, if they'd simply held up the warrants and said, and read those words and says, Detective Stoddard, is it true or not true that Ross Harris searched about how to kill small animals in a car or something like that? Stoddard would have had to say, no, that's not true. And then they could say, well, has anybody else ever said anything different than that? And that might have opened the door a little bit to getting into this with Murphy. But they weren't able to get that in with Stoddard. And so when Murphy took the stand, the judge ruled it was all hearsay, and they couldn't get into that with Murphy either. So that's going to be an issue for an appellate court to look at as to whether or not the judge made the right call.
And how strong of an issue do you think that is?
How strong is that issue?
What are their odds?
Well, you've got, it's either not error at all, or it's error that is harmless, or it's error that is reversible.
Right.
So I haven't seen the actual motion in limine that was filed
right.
because it's not been made public yet. I think that, I'm not saying Judge Staley made the wrong ruling. I respectfully would disagree with her in the sense that even if I thought it was maybe hearsay, I might have let it in anyway out of an abundance of caution, because I want to eliminate any issues that might be a basis for an appellate reversal. So I might have exercised my discretion if I were the judge and allowed them to do that, because they were not offering these statements to show they were true, which is the definition of hearsay. So there's a good argument to be made that it was not hearsay and that it was useful to impeach Detective Stoddard.
Okay. All right. I'm going to answer a few questions. Allie Oops says, did Leanna actually say she thought it was an accident? And yes, she did. Yes. She did say that, and she's very clear about that. So Allie, see, Gatorbait asks, was the second minor hidden because at the time she was underage, but now she's 19? Yes, that is why we didn't see two minors testified, but one is an adult now. She's 19, but because she was under 18 at the time of the sexting, they didn't show her. So we didn't see her or hear her. We just heard reports came out afterwards from reporters in the courtroom.
Let me just also mention the judge has discretion to not televise any of this. So, right. And so she can't keep reporters from going into the courtroom and watching, but she doesn't have to show the world. So this judge is one that is very much in favor of open courts, but when it comes to protection of minors, she's very big on that.
Okay. Gray Hughes wants to know about that phrase, we all need escapes. He wants to know why the state is allowed to keep bringing up that phrase when, in Gray's opinion, there's nothing nefarious about that phrase. Because I guess what he's saying is what a lot of us have said, which a lot of us parents have said, look, we all need escapes.
Well, it's the reason they're able to keep bringing it up is because it's already been admitted into evidence. And once something's in evidence, you can wave it around. If it's a document, you can bring it out with every witness, whatever. It's the state's theory is that this was the conversation he was having with an anonymous person using the Whisper app on his iPhone on the very drive from the Chick-fil-A to where he worked. And it was in response to someone who said that they were tired of being married with children and the novelty had worn off. And that was a anonymous post on Whisper that got Harris's attention, and he thought enough about it to respond to it and to carry on a dialogue while he was supposed to be taking his child to school. So they're saying that might give the jury some insight into what he was thinking. And here's where they're going with this, I believe, is that this is an idea that Harris knew about. This is something he thought about. He obviously had watched videos about how dangerous it is in the back of a car. We've seen him make statements about, at least from some of these witnesses, about his son being the only thing between, going back to the single life. And the argument, I think, is being set up that, this was something that at the very last minute at Chick-fil-A, he decided, I'm going to go ahead and do it now. And then flash forward 12 hours at the police department that evening when he's alone in that room and he says, what was I thinking? So they're going to make the argument, I believe, that this was something that was in the back of his mind that he hadn't really thought about doing or made up his mind about doing until that drive between the Chick-fil-A and that first red light, which is about 20 or 30 seconds. And at that moment in time, he said, today's the day. I'm just going to go ahead and get out. That's where they're going with it. I'm not saying that's what happened, but I think that's the argument.
Yeah. So you put that together with at that moment is when he sends the message back on the whisper out to the woman saying, we all need our escape. I love my son and all, but we all need our escapes.
And then within a minute or so, he closes the door on Cooper.
Yeah. Okay. Let's see. Let's talk about, I have more than one question about the possible sentences. So I know that we've talked about life without parole, but isn't there a possibility of life after and then parole after 30 years?
Yes, that is possible. I think right now that the consensus is he's sitting on about 12 years. He's going to get 10 for the attempt. It's attempted child pornography. Basically, he asked the underage girl.
That counts 6.
Right. He asked her for a photograph that he didn't get. So that's the attempt. And so that carries half of it would be a 20-year sentence. So that would, because it was not a completed crime, it carries half of that 20. So that's 10. Each misdemeanor, the last 2 counts involving different people or different instances, transactions, the judge could stack those consecutive. So we're probably sitting on about 12 years. I've seen Judge Staley give plenty of consecutive sentences, so I don't think she would hesitate to do it. If she's going to get a life sentence.
I'm sorry, you think about 12 years on count 6 through 8.
Yeah, and if she's going to give a life sentence, in this case, he's probably going to get life without parole. But in Georgia, it's up in the 30-some-odd year range before you're eligible. So if you take a life sentence with parole and you stack another 12 years on top of it, and then keep in mind, he's got another indictment coming behind this for child pornography. His future is not very bright.
No, well, I mean, I think we can all agree, at least most people, everyone I've ever talked to agrees he's going to be guilty on count 6 through 8. I don't know what's going to happen with the rest, but he does have that other 8-count indictment we talked about last time. You can find that on courtchatter.com on the Ross Harris archive page. We have it, and he's got child pornography charges there and other things with these are different minors. And he's going to stand trial for those. I don't know, maybe he'll plea out.
In those cases, because they've either got the evidence or they don't, and it usually is very strong when they do.
Okay, let's get to some more questions. Linda says, even on autopilot, even if he was driving, and not thinking, he received a text from his wife that afternoon asking if he talking about Cooper. Shouldn't that have triggered a memory? Because there's going to be a memory expert come up, right? So we're going to have a memory expert, I believe, testify for the defense and about how you forget things. And I don't really know all the details. You probably know more. But, why wouldn't have an email from the daycare triggered it? Texting between him and his wife talking. He says, are you going to pick up my little buddy today? Why aren't those triggering him?
Well, he sent a text message to Leanna asking her when she was going to pick up his buddy. And that was around 3 or so in the afternoon, as I recall. And then she responded back a little while later, wait, you're not coming home first? So that exchange seems to me to be equally consistent with parents who just aren't on the same page about who's doing what as far as child care is concerned. And for the sake of argument, let's say he really did believe he had dropped his son off. It's a reasonable question to ask to your wife, when are you going to pick him up?
Well, that was actually another question. Do we know, have they brought up any other texts where he asked her that on other days?
I haven't seen any, but I have seen, and I think we've heard testimony that they frequently discussed Cooper throughout the day. We've heard that from time to time he would send pictures of Cooper. He would go to Cooper's daycare and take pictures in crazy costumes and send those all around. So we've heard some testimony that there was, generally speaking, a dialogue between husband and wife that had to do with Cooper. So this one email exchange, it's interesting, but it certainly doesn't prove much.
Right. I mean, I think most of us, not having been in that situation, when we try and imagine it, we think there are several triggers throughout that day where all of a sudden I would have said, oh, I never dropped him off. But if you don't believe this is intentional, then that never happened with him. Okay, Mary Wainwright. What do you think about the fact that Harris made plans for a cruise the day before the incident? Was he setting up a defense? So for those who don't know, we've heard testimony about they're planning a cruise with his brother's family, planning to take Cooper. Then there were other searches where he searched like an adult-only sandals resort, but that wasn't to do with this cruise. So setting up a defense, I don't know. In my opinion, I don't look, if this was intentional, I'm not sure he put that much previous thought and had all of this backup. Maybe he did. I don't know. I never know what a killer.
Well, let me tell you something that I can just tell you from my own personal knowledge, because I've been in that parking lot at the Treehouse a few times as recently as today. Like I said, I went and looked, and because I wanted to see. I had a question about the security cameras, and they are very obvious. I mean, it is really obvious as soon as you turn in there. There are security cameras everywhere in that parking lot. And Ross is an IT guy. Okay, so anybody who drives in there is going to see these things. They're actually mounted above these blue security lights, so they're really almost impossible to miss. So someone suggested that to me, I think it was today, they said, listen, if he was intending to kill his child, why would you go back to the car at lunchtime knowing that there's all these cameras? Why wouldn't you just go to work, spend your day, walk out at the end of the day, open the car, and start screaming, "Oh my God! Oh my God! Oh my God!" If you were trying to set up some act, put on the act that it was an accident, to stage an accident. So a lot of people are saying the fact that he went to his car at lunchtime proves that he really was clueless about where Cooper was, because you would have to know that there's security cameras out there, and if you're in the process of murdering your child, why do you go and go out there at lunchtime? Right. So there's more than one way to look at all this stuff.
Right, of course. This is all going to be discussed in that jury room. I promise that. All right. Allie wants to know why they grouped all the charges together. I believe she means, why are the sexting charges included in this murder trial? The defense did try and separate this. They tried to get two separate trials. The judge ultimately allowed it in, and I'll let you speak to why that was.
Well, the prosecution in any given case, not just this one, if they have a theory of motive, they're entitled to prove it. If it's rational and reasonable, they're entitled to try to prove that. So if their theory of motive is that he was tired of being married with kids and he was looking for an escape, then they would be entitled, according to the judge's reasoning, to show all of this stuff together. So I think that this evidence would be admissible to prove motive anyway. So whether or not they, as far as the charges, I think is beside the point, because even if they had severed the indictment, I believe evidence of extramarital affairs is relevant to their theory of guilt, and it's also relevant to show that he was not being truthful to the police when he said he had a happy marriage. So I think this stuff would have come in anyway, even if he were not charged with these offenses.
Oh, good. Yeah, that's why the charges are all together, and that's bad for the defense. Okay. Joe has the question about the jury view. So the jurors were taken outside to view the SUV in question here, Ross Harris's car. And there was a lot of argument in that courtroom from the defense about this could be considered doing an experiment, which is not allowed. Jurors are not allowed to do experiments. Their argument was these are not the same conditions. The sun is not in the same position, reflecting on those partially tinted windows they have in the back, that the jurors are getting to walk all the way around the car. Well, we don't ever see Ross walk all the way around the car. All 12 jurors are not the same height as Ross Harris. So, you know, they're going to take what they saw when they went out to that jury view, and they're going to say to themselves, more than likely, I can totally see in there. I would have seen Cooper's head. You know, they also poked their head in the open window, things like that. So the defense's big argument was this should not be allowed. This is experimenting on the jury's part. But there is the other side of that, to where this is a piece of evidence and the jury is allowed to view evidence. So why don't you talk about that?
Okay, if a hammer is a murder weapon, the hammer can be brought into a courtroom. The hammer is going to go back in the jury room, and the jury's going to have the hammer. They're going to be allowed to hold it. They're going to be allowed to manipulate it. They're going to be allowed to play around with it if they want to. And so this car was actually, they put a sticker on it, an evidence sticker, state's exhibit number, whatever, and it was admitted into evidence. Now, it's going to have to be stored somewhere while the case goes up on appeal if there's a conviction, but it's obviously not going to be physically present with the rest of the evidence that would go up to the appellate courts. But it's a piece of evidence that they would otherwise be allowed to have in their jury room. And I guarantee you, if the jury asks during deliberations if they can go back out there and see it again, she's going to let them, because they're entitled to examine any evidence that's admitted in the trial, with very few exceptions. And that has to do with writings and videos and things like that. But physical items of evidence, they're entitled during their deliberations to inspect the stuff and to have a look at it and to even touch it. So there's no problem legally with the jury doing what they did. I don't think it was presented to them as a recreation. And they may have more questions, and they might even want to see it again.
Hey, look, if I'm on that jury, I want to see that car for myself. So that, you know.
Absolutely.
Joe, also that same question goes into, he says, isn't the defense that not that Ross couldn't see Cooper, but that he didn't see him? So what good did it do to have them look at the car?
Well, you're going to hear this argument from the defense, I think, in closing. Ladies and gentlemen of the jury, you all saw the car. And a lot of you, we saw you going out of your way to look at that car seat. And that's fine. But what you cannot know from the evidence presented at trial, ladies and gentlemen of the jury, is where Ross Harris's eyes were. Were his eyes at his phone, which he was so in love with? Maybe, but the prosecution has not proven to you that his eyes were pointed at that car seat. And so remember that when you're deliberating, that it's not that he had the opportunity to see it. They have to prove that he did see it. And there's nothing about these security videos, nothing about these 3D images that show you where Ross Harris's eyes were pointed. And so that's the defense argument to get around that. And let's see what the jury decides to do with it.
Okay. Kathy has a question about when Leanna, goes back to Ross used to send her pictures when he would drop Cooper off at daycare. Leanna testified about this. So the state has sort of, said that his actions started to change in the time leading up to this day, and about things to do with Cooper. And one of the things was when he dropped Cooper off at daycare, he would take a picture and say, look how, he's fine, or he's having a good time, he's not crying, and he would send that to Leanna. But he stopped doing that in the weeks leading up to this day. And I guess the state is trying to say that he was backing away from things about Cooper or being attached or that close to Cooper, things like that. Leanna testified that, and this is what Kathy's saying, didn't Leanna tell him to stop sending them every day? She testified that as a new mom that had to go back to work, she really did not want to leave Cooper at a daycare, and she was struggling with that. So when he was younger, she felt comfort in the fact that she had asked Ross to send pictures that's showing that he's okay, he's not crying, he's fine. But as he got older and was was moved to the toddler 5 room, and she said even when she would drop him off, she noticed he would just go in and run away from her and run right to his toys and right to the other kids. And he was just like, bye, Mom, you know. So and so after that, and she said it was about March of that year, she told Ross that she feels better about it, and that if he didn't want to take a picture every day, he didn't have to. So that's that testimony.
Poking holes in the state's case, one little hole at a time. That's the idea behind that. It is consistent with their theory that he was disengaging, but there's also a reasonable explanation. I used to take pictures of every time my son, who's now 5, would get up to bat playing, pee-wee baseball, but I don't take pictures of him every time he's at bat now. I think it's just something that parents, they understand why that might happen. Okay.
If there is a hung jury on those top charges, do you think the state is going to retry?
That's an excellent question, and I've been giving that some thought over the last few days, because really it's starting to wrap up, and the question is, have they proved malice? And there's also a question about, can the defense somehow convince this jury that this was nothing more than an accident or ordinary negligence? We got some experts coming up tomorrow. So if there's a hung jury, on counts 1 and 2 and a conviction for felony murder on count 3, I say no mistrial. I mean, no retrial. I think that they get their life sentence, they move on to the next indictment. But if they get a not guilty on all the murders and the child cruelties, the state's got a very tough decision to make. Does everybody just stay down in the Georgia coast and continue eating shrimp and grits for another month or 2 while they do it again? Or do they come back to Cobb County to regroup and see where they go from there? Maybe they try him on the second indictment and see what happens before they decide to whether or not they're going to retry the murder counts. That's a very good question. And at some point, you got to think about the cost of this and the practicality of keeping everybody down 6 hours away from here for quite so long.
Yeah. Well, and this has already cost a lot of money. I'm just going to do a couple more questions, and we're going to wrap this up because we've already gone longer than you and I agreed to.
That's fine.
Okay. Okay. Gatorbait wants to. She says something she's been told but doesn't know the truth of it because it hasn't been brought up really. Was that after he buckled Cooper into the car seat at Chick-fil-A, he then went through the drive-thru because he forgot something. Now, she piggybacks that on with saying didn't we overhear Maddox say something about Chick-fil-A receipts on the 18th? So what do you know about that?
Well, there was evidence in the case that on many occasions he went to the drive-thru, and there was evidence from the 18th that he did not. I don't know that I 100% follow the question that was being asked.
I think that takes a little more time than just leaving the parking lot and going right to work.
Oh yeah, absolutely. It goes to the change of routine, which we're going to hear about through some of these experts, especially this forgotten baby syndrome, or if that's the correct name for it now. A lot of it has to do with when people change their routine. The state got some preemptive shots off on that by proving, I think, to most everyone's satisfaction, that Ross was the person who took Cooper on most days. So not taking Cooper to daycare would be a change in routine. Taking him to daycare would be the routine. But the receipts, I think, have to do with the frequency of drive-through versus eating in. Okay,
let's wrap this up by talking about tomorrow and continuing. What are we going to expect now coming up in the defense case? Why don't you tell us?
Well, if they call all of the experts that we've heard about in pretrial motions, there's at least 3 expert witnesses in the stable for the defense. One of them is an expert on this forgotten child syndrome. He apparently was evaluated. Mr. Harris actually spoke to him, and he made some conclusions based on his review of the evidence and talking.
Is that Diamond? Is his last name Diamond? Do you know?
I think that's Diamond, correct. There's another physician, the name escapes me at the moment. It's a pathologist from, I think, San Diego, who in some pretrial motions, we learned reviewed some of the medical examiner's work in the case and refused to speak to the district attorney without being paid $250 or $300 an hour or something like that. So there was some motions to compel the defense to turn over their notes from that doctor. So we're going to have possibly another medical doctor, and then another doctor, and I'm not sure if he's a psychiatrist or psychologist, but it's someone who has to do with memory. And so we've got three of them at least in the stable that we believe, based on motions, hearings, people that we've heard about before, and expert witnesses. It's doubtful that they're going to bring all of them in the same day, because it's very expensive to do it that way when none of them are from Brunswick. Some of them are from the West Coast even. So you're going to want to stagger those and maybe have one expert per day. So we might see a short day Thursday and Friday. Maybe they've got some short witnesses to mix in here or there, but scheduling these witnesses usually is specifically planned, and the judge is in on it, and they know what day each expert is going to come. So we probably have 2 or 3 more days of the defense case. Then wouldn't surprise me to see some rebuttal. The defense also has a couple of the prosecutor's witnesses subject to being recalled if they choose to do that. So we're a few days away from the defense resting, but maybe not too many days.
Okay, so I think we will probably do one more show, you and I don't know, maybe 2, maybe if jury deliberations go on for a long time, talking about this case. Maybe we'll do one at the end of the defense case and then during jury deliberations. Go ahead.
Depending on the timing, I hope to travel to Brunswick for the closing arguments. I don't know that I can really afford to stay for all the deliberations, because who knows how long that's going to take. But we might do one from Brunswick. We'll see.
Okay, I actually want to say that Phil has attended all the pretrial hearings. They happened right there where he is based, and he was able to go to all of it, and we expected him to be our eyes and ears inside that courtroom, and then they moved it 6 hours away. So now that's obviously a problem. He has a life. He has a practice he's running. He has a wife and kids. He's not going to go there. So it has been in our benefit that happened. I just want to say that, because now we have had Phil Holloway at our disposal in our chat room almost every day. Come in there, stop in there, Phil's in there talking about this case, and we've been able to do these shows with him. So selfishly, I'm glad that Phil couldn't go and attend this trial every day, but that would be actually great if you can make it to the closing arguments, because what I want that you're not getting from just the regular reporters, which also a lot of them most of the time are in a media room, because in the courtroom they're not allowed electronics. So if they're in there, they have to just handwrite notes. So I understand why they're not in there. But what I want and what trial watchers want are jury reactions. So it'd be great if you could be inside the courtroom for closings and get a lot of that about how the jury takes both sides. So anyway, I want to thank Phil again. Follow him on Twitter at Phil Holloway ESQ. He's on Facebook. Go and like his page. I retweet all of his stuff, so if you can't remember how to find him on Twitter, you'll see him on mine, and then go in and follow him. He has been such a great resource for us that I can't even tell you. Been doing this for years now, and for all the people that have been watching trials for years, we don't always get this in depth from a legal expert. So I'm very grateful to you, Phil, and I want to just say thank you again, and we'll do this maybe next week.
Well, I'm happy to do it, and the chat room is a great place for me to keep an eye on the trial as I do my work from my office. I do have a law practice, and thanks for mentioning my Twitter. I changed my Twitter handle a couple of years ago, and I lost a lot of folks, and so I need a few more followers if anybody wants to keep up with any of this stuff.
That's right. Follow Phil.
Yeah, but who really wants to hear what I have to say about trials anyway? So if you don't want to, that's fine. But I really appreciate it, and happy to help out.
Okay. We'll talk to you all later. Thank you.